So we'll go ahead and get started here. We are delighted to have this session on family law today, and I will just quickly say that we're pleased to have Samantha Gemberling and Brian Lake here, and I know they have a lot of information to cover, so I'm going to go ahead and turn it over to you.
Good afternoon, everybody.
Hi, everyone. Brian Lake, obviously joined by Samantha Gemberling. And today we're going to be covering what is, I think, arguably the broadest and most impactful package of family law reforms that has passed in the history of the state. There may have been some previous legislation that was equivalent to it, but I don't think anything bigger than what happened during the 2024 session. So,
By way of introduction, I am a family law attorney here in downtown St. Paul. I say here, you cannot see that I am here in downtown St. Paul. I am also the legislative chair of the American Academy of Matrimonial Lawyers Family Law section. And so I worked quite a bit on this legislation with Brian, and Brian can tell you quickly about his background.
So I'm an attorney based out of Minneapolis, and I have been the lobbyist for the MSBA for a while now, 15 years or so. So Samantha and I spent a considerable amount of time over many, many, many years working on the elements of this. So quite a bit to cover today. And so I guess what you'll learn today is just we're going to cover briefly how the legislation was created, and the conditions and factors that led to it actually getting passed in 2024 after kind of a long wait. Then we're going to spend most of our time kind of giving you an overview of the major changes in the legislation, which affected 4 areas of family law: assisted reproduction, prenuptial and postnuptial agreements, spousal maintenance, and parenting time. So we will cover all that. And then as we get toward the end, Samantha is going to give you some practice tips and the pitfalls to watch out for with the new statutes. And as mentioned, if you want to ask questions, go ahead and put those in the chat, and then we'll try to save a little time at the end to address any remaining questions. And then if there's time, we'll give you just a brief preview of what family law issues might be on deck for the 2025 session. So as I mentioned, it took quite a long time to get this package of legislation put together and passed. And for me, the story really starts 12 years ago. There was a pretty bitter battle over 50-50 custody presumption. And the House that year in 2012 passed a bill. The Senate didn't want to go quite that far, so the Senate sent back a bill that had a 35% baseline presumption for parenting time. And as all the family law practitioners watching know, current law is a 25% baseline. So the 35% bill went to Governor Dayton. There was, as I mentioned, it was a really contested issue. It was essentially a lot of very impassioned shared parenting advocates on one side, and then the Bar Association, the AAML, legal aid, and domestic violence groups on the other side. So Governor Dayton was hearing about this from a lot of different angles. He ended up issuing a pocket veto. And in his pocket veto letter, a pocket veto essentially is something that can happen at the end of session where the governor doesn't officially veto it, but essentially doesn't sign it into law, and it has the effect of a veto. He also issued a letter along with it saying, really encouraging all the stakeholders to work together. That led to the creation of the Custody Dialogue Group. So that group included stakeholders from across the family law spectrum. It included attorneys, judicial officers, child psychologists, shared parenting advocates, legislators, ADR professionals, all sorts of people. And I would say early on, those meetings, which had a professional mediator, were very tense. There just wasn't a lot of trust in the room. And over the course of a couple of years and really, really hard work and many, many meetings, that group put together a package of compromise family law changes, most of which was enacted in 2025. That was a really big lobbying effort. I think prior to this year was probably the biggest one in family law in quite some time. And after that, things kind of cooled down in the parenting time area for a while. But in 2016, the MSBA and AML were contacted by a grassroots group that was interested in changing the spousal maintenance statute. And essentially, they wanted to get rid of permanent maintenance. And we had a meeting in this very room that Samantha and I are sitting in right now. It was a challenging meeting. I don't think we really got anywhere that day. And I think if you had asked either of us, coming out of that meeting, how things looked, we would have said, not very promising. But I think the one thing that, at least on the attorney side of things, that everyone agreed on was the maintenance statute was pretty out of date and needed to be addressed and updated. The question was just how. And we continued to meet for the next year or two with the grassroots advocacy group, but eventually their leader had his personal litigation resolved, and he kind of dropped off, and nobody really picked up the torch for them. But the MSBA and AML continued to work on the issue, especially the AML. They formed a group a special committee that worked on trying to figure out a way to update the statute. So that was going on. And that work kind of wrapped up around 2019, 2020. Around the same time then in 2020, there was another really tough battle over a 50-50 custody presumption. That ended up basically dying in the legislative process on a tie vote on the House floor. And after that, in the summer of 2019, the MSBA, the AML, and 3 different shared parenting advocacy groups started meeting to try to come up with, again, kind of what we had done in 2013-14, try to come up with some compromise areas of agreement. And we spent, I'm sure, well over 100 hours of meetings that summer and fall, and we're really close to having a package put together. But 2 of the shared parenting groups decided they wanted to focus on 50-50 custody and not the stuff we had been working on. We were fortunate that one of them, the National Parents Organization, one of the 3 groups, stayed with us and kept working on it. That work continued over the course of the next 5 years. We had many meetings with stakeholders, including legal aid, who worked really hard on it, domestic violence groups, and other stakeholders trying to figure out what we could do in parenting time to move things forward. At the same time, there were some negotiations going on the spousal maintenance proposals, prenuptial and postnuptial agreements, and assisted reproduction. All of that kind of came together in time for the 2023 session. But that year was the first time that the DFL had had total power at the Capitol for 8 years. They had a backlog of priorities. It was also a budget year, which typically takes up about half of the committee and floor time in a budget session. So there just wasn't really an opportunity to move anything until 2024. And so the conditions were there. We were very lucky. We had 3 really strong, supportive authors. I want to give a shout out to Representative Kelly Moeller, Representative Peggy Scott, and Senator Bonnie Westland, who some of the family law practitioners on here might know personally. And they were really helpful. We also had supportive judiciary chairs, Representative Becker Finn and Senator Ron Latz, who helped us move the legislation through the process. We were able to get it through the House and Senate and get it signed by the governor, and that makes it sound really easy. But I can assure you it was far from it. And there were many moments, probably 3 moments during the session, where I thought the bill was much more likely to die than it would be to pass. So it was really good to get all that stuff done. As I mentioned, there was kind of 4 separate negotiations going on. The AML had a small group that was working on prenuptial and postnuptial agreements. They also had the group that I mentioned working on spousal maintenance. And then there was another kind of independent subset, even smaller one, of attorneys who specialized in assisted reproduction who were working on some language in that area. But I think the toughest thing for sure was the parenting time negotiation. As I mentioned, there were multiple stakeholders there with different points of view. We were making modifications on that language from 2019 all the way into the middle of the session, and then even catching some technical stuff we had to fix on the House and Senate floor at the very last minute. So that was probably the longest and toughest negotiation of my legislative career. So it was really good to get that done. So that's kind of the background on how everything happened. And now we want to get into more of the specifics of what was in the legislation. And we'll start with the parenting time language, and I will turn things over to Samantha.
Okay, so I'm going to go over the parenting time changes. There were some significant changes in the legislation this year, and it's all things that you should be familiar with. And Brian kind of gave you the background. So people will sometimes say, well, why did you do this? Or why didn't you do this? Why didn't we modify, 518.17, the best interest factors further? There's always appetite for different types of discussion at the Capitol, but these were the things that we were able through the negotiations that Brian referenced to get done. There is a change to 257.025 regarding custody and parenting time. That is more of a technical change, just making it clear that unmarried parents are just as entitled to parenting time and not visitation. There was antiquated language at that point in the statute that needed to be addressed. The next really significant change, I think, is the public policy section. The public policy section can now be found at 518.0011. And this was I don't want to call it, I don't know what's this was a big piece, a big deal, right? To people who wanted, you got to remember that people coming to the table wanting a full 50-50 parenting time presumption, right? And that has been the things that Brian referenced has been an issue for many, many years. And so one of the things that underlies that presumption, like why do people want that, is because people want there to be equal recognition for both parents, right? That's not really a gendered consideration. I think at the outset of it, probably, even in the custody dialogue group days, there was a focus on fathers per se. But, as we know, as family has developed and changed, how we can develop your family, how you can grow a family, all of that has changed dramatically. So the public policy of the state, we decided was best to encapsulated to say that a child is entitled to frequent and substantial contact with the child's parents, as long as the parents have shown the ability to act in the best interest of the child. It also ensures that parents and caregivers provide a safe, nurturing environment for the child and encourages parents to share the rights and duties of a child. So why a public policy statement? Well, it is quite uncommon to have a public policy statement in the Minnesota statutes. If you look around, you'll find them in places like the juvenile code where we want to sort of set out what the court's goals are. So I would definitely say this is a good addition and something, I'll talk about this a little bit more in our kind of tips and pitfalls conversation, but I want to mention it here, which is that this is where you want to start with parents, right? Like this is the public policy of the state. These are the things that you want to think about when you're discussing parenting time with clients. That we do have a presumption that, both parents have a significant and meaningful relationship with kids. So there's also changes that are quite substantial to the temporary hearing provisions of the statute. And these came again out of a desire, a discussion to certainly make sure that people don't have situations, which happens, we all know in practice all the time, where you've got an intact relationship. People may not be married to one another, and maybe they are, right? And they are parenting the child and things are going along fine. And then they decide either to divorce or they decide to end the relationship if they are unmarried parents. And unmarried parents there find themselves in a sort of second-class citizen status because if they haven't gone to the court and established parentage and established their right to parenting time, it can be the case that a significant amount of time in the life of a young child can pass before that parent gets themselves into court, gets paternity established if they're the father, and gets an access or a parenting time schedule. So that was one of the things in working with the parenting groups that they had raised with us repeatedly is how do we prevent substantial denials of parenting time? I also know from working with various stakeholder groups is another significant concern was how do we address, certain situations with finances. And we have a slide about that in just a minute. But these were sort of the key component things we wanted to address were compliance remedies, right, for not complying with parenting time, urgent scenarios that are, as I've discussed this when part of what Brian and I do when you're trying to move a piece of legislation forward is you go to the Capitol and you talk to legislators to legislators in the House and the Senate. And they will say, well, why do you need this? Why is this important? Give me a scenario. And so what we have had, because now we have a far better remedy, what we had in our prior statute is you had your typical, you can bring a 21-day motion, you call, you get a motion, who knows how far, I just called in Ramsey County for a motion hearing date. They're out into March. So that is certainly one way of doing it. And then our other extreme was to have an emergency motion, right? And so one of the things we wanted to address was situations that were urgent, but that were not emergent, that were not going to get you under the requirements for an emergency motion. And then we wanted to make some, clarity about some of these parenting time parameters, and we'll talk a little bit more about that. One of the edits to the statute that we think was significant as well is the remedies for a denial of parenting time. And I'm going to go back and just talk about all the temporary support and parenting time changes first, just because I want to cover those before I get into some of the remedies. Most of the temporary changes can be found in 518-131, and they lay out that if a party has been denied parenting time with a child for 14 or more consecutive days, or if a party has been unreasonably denied access to necessary financial resources and support during the dissolution process, that the court can hold a priority hearing under this subdivision within 30 days of the party's request. And, obviously the additional language there indicates that the court can consider credible allegations of domestic abuse, substance abuse, maltreatment findings, and neglect if a parent was coming in and saying, hey, there's a really valid reason why I have been denied parenting time. And again, you have to be mindful of reading the whole statutory subdivision here. This is not a situation where, people can just say, oh, it's been, I anticipate, and we anticipated when this was passed, that people would sort of try to read this to sort of maneuver around what are some good faith parenting time disputes. And so my advice, again, and just in case we run out of time for tips and tricks, I want to be sure to kind of talk about this at the time. Be sure that you read the entire statute and what provisions it requires. This is not a bypass, right, of the necessary things that you have to do to prepare and plead your case in the family court context. It's not a way to get around a true temporary motion that's timed under the regular rules. So those were important pieces that we wanted to consider and wanted to address in kind of getting some of these parenting time and withholding of financial support pieces addressed. The sort of freeze out provision of this statute is to address situations which we've all, I'm sure, had where someone does not have access to financial resources. So they can't, for example, they can't pay for alternative housing, or they can't pay their car payment, or they don't have access to things that they need, reasonable, even under the operation of the summons, right, which says that you have access, you can utilize funds for the necessities of life. But if those are being withheld, right, due to a power imbalance in the marriage, due to a division of labor in the marriage, that one party just wasn't familiar with how the financial resources worked, all of those are things that freeze out provision is attempting to address. And the key component reason for doing that, and what we shared with the legislature, was we don't want people negotiating from a position of vulnerability. We don't want people saying, well, I have to take whatever offer I get because I don't have any money and they're not going to negotiate with me and I can't afford to do anything because I don't have access to resources, because that just makes their entire ability to sort of negotiate the divorce compromised and under duress, and we wanted to avoid that kind of issue. So I'm going to double back to this remedies slide just to kind of talk about what we sort of went through in discussing the remedies for parenting time. And I think if you've ever tried to enforce a parenting time order, you will know that it's a challenge to get a comparable remedy that actually influences change. And these changes are at 518-175 subdivision 6, and lay out that if there has been court-ordered parenting time, and a good thing to point out here is court-ordered parenting time also includes and is designed to include an order from a parenting time consultant, a parenting coordinator. Just going to take a little side note. This is how my mind works, right? Thought bubble here, which is Minnesota doesn't really have a parenting coordinator, but other states do. So if you have a order transferring in from a different jurisdiction and it's a parenting coordinator jurisdiction, we wanted to pick that language up. So we're aware that Minnesota doesn't have a parenting coordinator. That's not there on accident, though. Special master, other court-appointed individual who is authorized to establish or modify parenting time, or a binding or agreement or decision under 518-1751. So if you have an enforceable court order for parenting time, we then went through the remedies that you have available to you to actually do that enforcement. And those are laid out in that same portion of the statute. And there was things there that just didn't make sense. That, this was a very experienced group of practitioners sitting around this room. And we were talking about, has anybody ever gotten a civil bond? How does that civil penalty work? Who is it paid to? So, there was just things in the old statute that didn't seem to actually bear fruit such that you could address a denial of parenting time. So really the goal of these provisions is to kind of give some teeth to a specific set of kind of consequences if there's a repeated and unwarranted and unreasonable denial of parenting time. And one of the pieces that is in that section of the statute is that you could arguably bring a motion to modify legal and physical custody. There's also sanctions, like monetary sanctions that the court can use. And finally, there's a requirement that there is a fee sort of must provision. A lot of these attorney's fees provisions, and we're going to talk about a change to the attorney's fee statute in just a second. But a lot of those are provisional or mays rather than shalls. And this actually requires a shall, like the court shall reimburse the other party for costs incurred of a denial or interference with parenting time and award a reasonable attorney's fees, presuming that there's an ability to pay. That's what the statute requires. And so I think that cleanup of the remedies provision is really, really helpful to, help people who are engaged in a denial of parenting time understand that there's going to be consequences for that. And those consequences are going to be sort of real and something that hopefully will actually impact change. So I love this slide, just as an aside. It just made me laugh. What is the attorney fee loophole? Well, in the attorney's fees statute, if you've ever had a circumstance where you have needed to enforce a fully executed judgment and decree, a signed court order, you need to get a property settlement, you need to do something else. You have found that from the time of the violation, whatever it is, up until the time that you actually file a motion in court, that can be a significant amount of time, right? That could take months, that could take several letters to the other party, that can take negotiation back and forth. And then you can hit a point where, we are not going to get this resolved. And so then you go to the point of filing the motion. And one of the things you ask for, hopefully in your motion, is fees for noncompliance with the order. However, if you have ever tried to ask for fees prior to the filing of the motion, all the time that you spent working on it with your client, trying to get it done before you actually filed the motion, if you had a decree requirement to mediate, as an example, and you want to mediate before you file the motion, all the time that you spent there was not good guidance in the attorney's fees in 518.14 for being awarded attorney's fees for that situation. So that was the goal of trying to make that change in the legislature. And what we were able to accomplish is that provision was, pretty non-controversial once we explained to members of the House and Senate why we needed it and why it made sense. And I do think too that is going to be impactful to us moving forward. Again, it's a place where we will actually sort of have some ground to move. Other important notes, it's not a big ad, but a child must receive at least 25% parenting time with each parent. We always call that the floor versus ceiling. And that's just making sure that the court understands that the 25% parenting time presumption is like sort of the bare minimum that should be occurring. Obviously, if you have facts that support something less than 25%, and that absolutely happens and is appropriate at times, this is a presumption that can be rebutted. And then finally, the other big change is in the notice provision, and that's just making sure that the notice pieces are in the order, so people can't say, well, I didn't know that I had this obligation to comply with parenting time. One of the things that should impact, and again, just watching our time, I want to be sure that I get some of these things in here. Be sure you've updated your Appendix A. Because if you're using an old Appendix A, it will not have this notice and it's required to be there. So be certain that you've made those updates. So I am going to turn it back to Brian to talk a little bit about prenuptial and postnuptial agreements. Brian has the good or bad fortune of not being a practicing family law lawyer. So if he says anything that I need to jump in on, I'll find some tactful way to do that. But he is definitely familiar with these statutes and what we got through the legislature because we spent many, many hours working on it.
Yeah, and I want to thank Samantha for teaching me about this, and also a shout out to Attorney Lisa Spencer to really help me understand what we were doing in the prenuptial postnuptial part of the legislation. And I would say of the four elements of what turned out to be a family law omnibus bill, so all four of these bills were moving independently, and then the Senate merged them together into a bigger bill. But of those four elements, I think the prenuptial postnuptial agreement language got the least attention. It got very little attention, almost no attention. Excuse me. Almost all the attention was on the other three elements. So it doesn't mean what happened here wasn't important. It's just I think the average legislator probably has assets similar to the average Minnesotan, meaning for most of them, prenuptial postnuptial agreements aren't a super important issue that they want to be focused on. So, but in looking at the statute, which was created in the late 70s. One thing you want to note about the legislative history is part of a compromise at the time that was necessary to get the bill passed. They had the statute only apply to non-marital property, but not marital property. And then about 10 years later was the first of three, I think, really important Minnesota Supreme Court cases, the McKee-Johnson case. And there the court confirmed that the statute applied to non-marital property and said the common law applied to non-marital property. I'm sorry, marital property. The statute applied to non-marital property. Then about 2 decades went by, and the court took another look at it in the Kinney case. And there the court created a new multi-factor balancing test, a common law balancing test. But that was pretty much ignored by practitioners because that case dealt with an agreement that was signed before the statute was enacted. So it wasn't really seen as being super applicable. Then everything got very confusing about 10 years later in the Kramer case. So I think, on the initial read, it looks pretty clear. Basically, the court there said, again, confirmed that the statute only applies to non-marital property. And then they said that the balancing test that was created in Kinney applies to marital property. So it seemed like a pretty clear division. The problem was that the statutory definition of non-marital property includes property that is excluded by a valid prenup. So in other words, non-marital property could include marital property that was excluded. And then you have the other problem of many of these agreements dealing with both marital and non-marital property. So as a result of this decision, there was just a lot of confusion. Some attorneys are arguing that no prenuptial agreements were valid now. And because of all the confusion, there was a lot of challenges to existing agreements. And many attorneys started refusing to draft them because the law was unclear. And all of this was just not good for judicial efficiency. Obviously, when you've got a lot of litigation going on about existing things, and then you have the problem of, it's really antithetical to public policy to have people not getting these prenups drafted and avoid litigation later on. So the AML formed a small committee to work on coming up with some proposals for this. They did that. They ran those through the Bar Association's family law section and probate section. Obviously, the probate section had their own unique interest in it. And then that was put together and ended up moving as part of the package. So essentially what the draft tried to do is take the best pieces of the common law, take the best pieces of the existing statute, and kind of reshape them in a way that made sense and provided for more consistency and clarity. And there was a handful of elements to the new law that passed. So we can go over them here. So essentially, the first bullet point These were things from the Kramer case and the old statute that seemed workable and important to include. The second piece was from the McKee-Johnson case, and that actually leaves Minnesota in the minority of states that are enabling courts to consider whether agreements are substantively unfair. But that was considered a really important piece to retain for fairness purposes. Probably the most important piece of it was the third bullet point, which is establishing a single standard. So instead of all of this confusion about whether we're dealing with prenuptial or postnuptial agreement, whether it's marital property or non-marital property or both, and having different standards applying to each of them or being unclear about which standard would apply, there is now a single standard that applies to all of those things. And then the other piece that was important in there was when these agreements are signed less than 7 days before a wedding, the burden of proof is on the proponent. And this was never in statute, but it was something that experienced attorneys in this area had long done already. And they really wanted to keep this in there as kind of a critical component to prevent opportunities for duress. So those were the major changes. As I said, this kind of floated through the legislature. I don't really recall hardly any discussion about it in committee or on the floor. Everyone else was really focused on some of the other areas which got a lot more attention. One of them being the spousal maintenance changes. And I will turn it back to Samantha to talk about those.
And just for, those of you who are like, where in the statute is this, the anti-nup and prenup work is at 51911. And I will reserve my sort of tips and tricks on that if we have time. So I'm going to move on to the maintenance. So how did we get here? Well, as Brian indicated, we had this shareholder group, and I'm not going to kind of plow that particular set of ground, but there was definitely movement across the country. The American Academy, by its name, is a nationwide organization. And so the benefit of being a member of the Academy is you get to sort of talk with people nationwide, see what the trends are. And there has been different trending about spousal maintenance in different parts of the nation, like moving towards particular things or away from particular things. And our statute, has had a lot of antiquated points to it, a lot of points that did not really represent where we are as a country, where we are as an economy, where the marital division of labor currently rests. I mean, it just had some pretty dated components to it. So that was a big part of how we got to where we were of wanting to make changes to the maintenance statute. It also, didn't fully answer a lot of questions. I don't know if other people have this experience, but I certainly had a lot of experience litigating maintenance and having to litigate maintenance because the statute was not as clear as it could have been. And there was just also a lot of pieces where it just seemed like we could do better if we had a chance to do that. And so when we sat down to look at the maintenance statute, there was a group of 6 of us who did that. We all came into that discussion with different goals, different perspectives, different practice styles, different practice bases, right? Some people in that room really represented a lot of obligee spouses, a lot of, people who had been in a long-term marriage, who had given up their career, and then there was plenty of people who represented the obligor spouse who really felt like there was just a lot of weight towards making sure that people make efforts to move towards self-support. So that what you see in the current revision of the statute, which is in 518-552, is a compromise of a lot of different ideas, suggestions, thoughts. And we went over every single word in the maintenance statute as it had been drafted, every single word. And as you can imagine, with a room full of, I think I was the least senior lawyer in the room, so a room of pretty highly competent lawyers. We needed some help. So we had someone, Kevin McGrath, if anyone's familiar with him, mediate for us. And he did a terrific job and should get a lot of credit. If you're ever mediating with him in the future, be sure to thank him for his part in this, because it was a Herculean task. So on the changes to the statute itself, again, I'm gonna like tick forward two slides, and I thought I reordered these, but I didn't, so I can make it work. One of the things, the first thing that people point out that was removed in the statute is in the grounds for maintenance. One thing to remember, and I'll talk about this a little bit more, is you still have to establish the grounds for maintenance. You still have to establish entitlement, right? All these other things that we're going to talk about rest on the foundation that someone is entitled to maintenance. And one of the things that sort of came up in looking at the grounds or entitlement portion of the statute was the fight about appropriate employment. And one of the challenges that I have heard repeatedly, other people in the room have heard, is there was a lot of litigation about what's appropriate employment. Is it appropriate for someone to work, to go back to work? Do they have to go back to work? What if they go to work now and their daycare is more important than it's not cost effective, right? If daycare is more money than what you're earning to put your kids in daycare, does that make sense? So there was just a lot of discussion about that. And if you look at the statute says is unable to provide adequate self-support after considering the standard of living established during the marriage and all relevant circumstances. Now, the qualifier through appropriate employment doesn't need to be there. And it actually creates more consternation and litigation than it solved. So the removal of through appropriate employment doesn't mean you don't have to consider appropriate employment. It means you have to consider all relevant circumstances. So that is the background for that change and why that change happened. The next really significant change in the maintenance statute is the amount, the changes in the amount section. I'll find the slide in a second. But in the amount of maintenance, which is subdivision 2 of the statute, we talked about, it's this one. There we go. Ooh, see, sorry for the slide driving there. One of the things that we added in the consideration of the amount of maintenance, the factors that you have to consider, is the standard of living established during the marriage, which has always been there, right? And then the extent to which that standard of living was funded by debt. That is the new add. When we went over these factors with a fine-tooth comb, every single word, we didn't want to take things out that worked, that seemed to work in practice, that seemed to help people settle cases, that seemed to be illustrative for judges writing orders. And so when you look at the changes to the amount of maintenance, there's not a ton of changes. A lot of the stuff that we had worked, so it was not broken, so why fix it? But one of the things that was a challenge is this scenario. Spouse 1 brings their budget to your office, it's $10,000. Spouse 2 brings their budget to your colleague's office, it's $10,000 as well. $20,000 of combined budget, and the parties earned $14,000. That's not gonna work. We're not going to be able to have 2 households kept afloat by the same amount of money. And then, we have these budgetary issues. So the way to consider that is to look at whether that standard of living was funded by debt. Do these people have this budgetary problem because they have $60,000 in consumer debt, or they have 3 mortgages on their primary home, or, whatever the case may be for them. So we wanted to put that consideration in there because we thought it was fair and meaningful to do that. There is additions in D, which are not really additions. They look like a change, but they're really the moving of the loss of earning seniority retirement from E, where they had previously lived, into B. So that's more of a merger. It's kind of a modernization of the statute, retaining the consideration that one party may have given up opportunity to benefit the other party, but that's not necessarily limited to homemakers per se, right? Someone could have taken the less stress job, or someone could have taken the job where they can be home with the kids in the summer. There's other considerations there that can be considered besides, a traditional homemaker spouse. We also added the physical, mental, and chemical health of both spouses. Now, originally, that focus was on the spouse seeking maintenance, which led to a lot of issues and concerns, not the least of which was what if that obligor spouse, that historically higher earning spouse, had some challenges, right? Had burnout from their high power job and had, an alcohol problem that required treatment, and they, needed to take a leave of absence and their compensation was affected. And there's just a lot of factors on the side of the obligor as well that we thought it was fair to add that consideration. And the addition of, it used to say physical and emotional condition, which again, that is just sort of dated language. Whenever I read that, I would feel like someone is, laying on the couch, like it's like a frail condition. It's sort of like a little bit derogatory language that we wanted to change. And what you're really looking at is how are people doing? How is their chemical health? How's their physical health? How is their mental health? And how does that play in, if at all, to a calculation of an amount of maintenance? So those changes are there. We also made some kind of move around in F and G. We noted that the contribution of a party to the furtherance of the other party's employment or business remained relevant. And then we added at H, the need and ability for each spouse to prepare for retirement. Now, there's two important pieces of retirement in the maintenance statute. It is here in the calculation of amount, and it is also in the modification portion of the statute, which I'll get to in just a minute. But under the calculation of amount, you need to look at the need and ability for each spouse to prepare for retirement and that anticipated time of retirement. So that's the key component changes in the statute as far as it relates to amount. The other really significant change, obviously, is in the duration of maintenance. And I'm going to see if I can find the slide for that. Oops, too far. Oh, whoa, way too far there. So this maintenance change is the biggest change in the statute, but in many ways, I think from what I've heard, right, it may be the least impactful because many people were utilizing a similar sort of rule of thumb. Okay. But what the statute now lays out is there is a guideline for the duration of maintenance, and that duration of maintenance is calculated from the point of the operation of the end of the marriage, which is the filing of the divorce action. So keep that in mind. Again, in case I don't get to it, keep that in mind when you're deciding. You met with someone, they're thinking about getting divorced. They want to think about it. 6 months or a year goes by, they haven't initiated any action. So the end of the marriage is when the action is initiated. The length of the marriage is the period from the date of the marriage until the date of the commencement of the action. And then you calculate maintenance with a rebuttable presumption based on the layout of the years in the statute. Marriage of less than 5 years presumes that no maintenance should be awarded. Between 5 and 20 years presumes that you're looking at transitional maintenance, and length of the marriage 20 years and longer is presumed to be indefinite maintenance. And I'm going to talk about those term changes in just a minute. But these durational guidelines were there to try and problem solve the issue of people fighting about how long maintenance is going to last. Us as practitioners not being able to give people good guidance of how long they could anticipate getting maintenance. A lot of the challenges in maintenance and in litigated maintenance especially was tied to that issue of duration. It also, and I'll talk about this a little bit more in the language choices, but that duration piece can really serve as an impediment to people being able to settle, right? They agree that maintenance is appropriate, they agree on the amount, but they just can't quite get there on how long the maintenance should be. And so that was the goal of the statute, is to try and sort of eliminate some of those disputes. Doesn't mean we won't have them. They're a rebuttable presumption. People will call me and say, Samantha, well, what if my client experienced a total disability in year 4 of the marriage? Well, then use your skills as a lawyer and go out and argue against the presumption. So then I want to talk about the language piece of this. Why did we change the language? What was the matter with what we had before? Well, it was an expectations issue for people receiving maintenance. If you're receiving permanent maintenance, if you're a recipient of permanent maintenance, that to you says, I will always get it, right? I've had many people come to me on a post-decree motion to modify as the recipient spouse, and say, well, wait a minute, they can't bring a motion, they can't bring a motion, this is permanent maintenance. Well, if the order was appropriately drafted, the order says, this timeline, or unless and until there's an additional court order, right? And people don't read that. They see it, they know it's there, but they don't understand that permanent maintenance is able to be modified under, the old statutory framework. And so the change to the word indefinite. Why the word indefinite? I assure you, hours and hours and hours was spent on indefinite and transitional. There's many other words. There could have been different words. In surveying, if you ever really need to go to sleep quickly at night, survey the 50 states on what terminology they use for maintenance, as I have done, and survey that legislative history and why people use that language. What we decided is for our state, for the goals of maintenance in our state, indefinite sort of lays out what we're trying to do. We're providing maintenance that's going to last as long as it lasts until there's a change. Temporary maintenance is now transitional maintenance. Again, similar framework. We are trying to move the obligee spouse from this point to that point. They need to understand that they should be moving, right? They should be trying to get skills that they need to be rehabilitated, to be able to self-support. They should be making other changes that they may need to get to a position of self-support. Maybe it's transitional until their kids are older and they can be in school. There's all kinds of reasons why it's transitional, but that was the reason why we wanted to look at more language that was just set appropriate expectations for people. That brings us to the issue of retirement and also essentially the issue of modification. The modification standard that is now in 518, 552, people would look at the red line and be like, oh my gosh, we totally changed everything. We did not. All we did is picked up what was in 518A in the modification standard that applied to maintenance and moved it into the maintenance statute. So the maintenance statute now operates all in one place in Minnesota law. So if you look at that modification standard, you will see language that you should be familiar with. However, the piece that we did add that was significant was the issue of retirement. I don't know how many people of you have handled retirement cases where you have someone who's been paying maintenance for 15 years or 20 years and they are at a position that they would like to retire. And that caused, again, a lot of unnecessary litigation about, can I retire? Am I old enough? Is it appropriate? What things do I have to consider? Do I have to wait until I actually retire to be able to bring the motion to modify? And so the goal in adding, and I think of the ads, the impactful ads to what we have changed in the statute and what we do every day, I think the retirement section is arguably the most impactful because it puts a clear set of parameters in a place where they had not previously existed. So the changes indicate that if you bring a motion to modify, that you need to either have retired at an age appropriate for your vocation, or you have to have reached your reasonable age of retirement as defined by the Social Security Administration. Why that number? Because there had to be a number, and that is a good place to sort of draw a line. And then there's a set of things that you have to consider when bringing that motion to modify, once we've determined if we're at an age where it's appropriate to retire. Whether a party has reasonably and prudently managed their assets since the dissolution of the marriage, right? We used to have a set of case law that said, and I just was reading an order issued maybe 4 years ago that said, well, wife doesn't have to use her retirement assets. She can preserve those. That has always been a challenge. Well, what if someone didn't fairly, they didn't take good care of the assets that they were awarded in the divorce? It was sort of problematic to us to say, hey, you got all these assets in the divorce, but you don't ever have to use them in retirement. And so that's why the other specific addition is the financial resources available to both parties. So my understanding of the legislation, my read of the language, and there is already, I've had some debate about what the financial resources available to both parties mean. I think it means all available resources, unless there's a reason to carve back resources. And that reason may be a great argument to argue that you can't double dip retirement. You can't ask an obligor spouse who already paid off their half of the retirement to then have to have that money counted against them if the other party didn't appropriately manage their assets. So I think that's something to kind of be mindful of as we move forward. So they are close on time. The maintenance is a big statute. Only other kind of quick thing I would add is that the changes here do not mean that you can walk into a case and be like, well, they were married for 8 years, so I get 4 years maintenance. You still have to modify or to establish that people are entitled. Don't skip over that entitlement step. I've seen people kind of start doing that or attempt to do it. And that's, yes, there is a durational guideline, but that does not mean everybody who's been married ever gets maintenance. You still have to establish the things that you always had to establish.
All right. And then the last piece of the legislation dealt with assisted reproductive technology. And so the first 3 areas that we talked about all had a lot of existing statutory language, case law that was applicable. And assisted reproductive technology had limited case law and then absolutely nothing in statute. So this is an area that has for many, many, many years been very controversial at the Capitol. There are some less controversial elements like in vitro fertilization. But I think the area that has drawn the most controversy now for a good 20 years or so is surrogacy. So this is not an actual photograph of the Minnesota legislature battling about surrogacy, but it might as well have been. I've been involved in several of these debates, both for the Bar Association and for a different client. They're always extremely difficult. And I think the first real big effort to get something in statute was in 2008. There was a bill that passed the House and the Senate, but Governor Pawlenty vetoed it. And that bill dealt with gestational surrogacy. There was an attempt a couple of years later in 2010 with a revised version of that bill. That passed the House and reached the Senate floor, but that was an election year, and there were some senators on the DFL side who didn't want to take it up and vote on it because they knew that Republicans would be offering a bunch of abortion-related amendments on it, as they had done in the House. And there were certain DFL senators who didn't want to take votes on that issue in an election year. And that ended up dying that 2010 bill. Then over the years, there were a couple different attempts, and one year the Bar had a very stripped-down version dealing with some really technical legal issues. We had really strong bipartisan support on that, but still couldn't get that. And that was a very stripped back version of it. In 2017 or 18, I think there was another attempt at a larger surrogacy bill that moved out of committee in the House, but it died in the Senate. And generally, these are partisan issues for the most part, but not always. Democrats are supportive of surrogacy legislation. Republicans are opposed to it. And there are some religious and social advocacy groups that are opposed to it. So there's really, really difficult to move forward. So things kind of started to move, however, in 2024. The background of this was this is a pretty niche area of law. There was a small group of attorneys who specialize in it that had drafted some language. And that got picked up as part of a broader effort to pass the Uniform Parentage Act. So generally in Minnesota, uniform acts are pushed by the state's uniform law commissioners. But before they bring them to the Capitol, typically they work with the Bar and other legal groups to try to work out any issues with the language, make sure it fits with Minnesota law and doesn't create any conflicts or other headaches. They attempted to do this with the Parentage Act with a large group of attorneys who just could not agree on what we should do, and that kind of died. However, there were a couple lawmakers this year who picked up that act and wanted to move forward with it in a pretty unvetted state. And there were a lot of concerns from the AML and the Bar's family law section about most of it just not being ready for prime time and potentially creating really serious problems. However, the assisted reproductive language that I talked about seemed to be really well vetted and solid and technically sound and ready to go. So essentially what happened was they took just that language, the assisted reproductive language, and moved that and stripped out all of the other parentage-related language. It still ended up being quite a debate. The bill moved forward in the House. I think it was about a 3-hour debate on the House floor, centered around the surrogacy language. It did pass and then moved over to the Senate. Now, the Senate was in a little bit different situation. They had a one-vote DFL advantage. It's a 34-33 split, and still is. Which essentially gave every DFL senator veto power over every single issue. And there was one DFL senator who has long been concerned about surrogacy, doesn't like it, and wouldn't support it. So the decision was made to strip the surrogacy language out and just keep some language related to in vitro fertilization and artificial insemination and move that forward. But even that proved to be a little bit controversial. There was some concern among certain advocacy groups that it would still affect surrogacy in some way. So on the eve of the floor vote of this giant package of family law bills, the bill almost died just over that. There were several hours of phone calls and emails and text messages trying to sort out some language that would make everybody feel comfortable. Eventually we got there, and the bill was able to get a floor vote in the Senate the following day. And like I said, this is a pretty niche area, but the attorneys that work in this area think it's going to really be helpful in eliminating a lot of difficult litigation that has historically arisen when parties have agreements, but relationships really fall apart, and they have these bitter battles over this. But essentially, a really good thing. And the first, as I said, for the first time in Minnesota's law, we actually have something in statute about assisted reproduction. I would expect over the years, and probably not in the upcoming session, but in future years, look for more discussion about surrogacy. Obviously, people are using it. The bill that was out there this year, the language that was out there this year, essentially just codified what courts are already doing. But the advocacy groups that were opposed to it, who I think you can boil down their argument to say that they don't want to treat babies like commodities that can be bought and sold. They don't want that language in statute. Even if courts are already doing it, they don't want to have statutory language to give it that kind of extra authority and legitimacy. So I would expect that to continue to be a really, really difficult battle. And I would expect most likely nothing will ever happen on that until we once again have probably a DFL trifecta where they're controlling both chambers of the legislature and the governor's office, which we will not have for the upcoming biennium, as there's an even split in the House. So that is that. I know we've just got a minute left. So is there anything you wanted to cover in here?
Just a couple of things. Just so you know, if you wanted to look at the assisted reproductive provision of the statute, it's at 257E. You can look at that there. There's definitely specialized people that can guide you on that, but that is the place where you want to look. So I am going to just give you a couple quick practice pointers and pitfalls. On the parenting time provisions, use the new statute as it's intended, right? I have already heard from people that have tried to get an expedited hearing and did not have the facts to support that hearing, and the court was not receptive to that. I've also heard from people who had the hearing, had the facts, had an appropriate basis, but you just have to remind the court, obviously in a gentle way, that this provision exists and that's what you're bringing your request under. I think we have to remember, especially through most of the state of Minnesota, these are courts of general jurisdiction. These are judges that are hearing many, many different areas of law. And if they, they are absolutely all doing their best to get up to speed, to get training, to understand what all the new statutes are. But I can tell you, because I work with Brian in the legislature, family law was like one teeny tiny piece of what the legislature is contending with and what the bar as a whole and the bar lobbyists contend with. And so just, be gracious with your court. And if they're maybe potentially not aware that this ability to do this exists, when you have the right facts for it, just, let them know that this is what where you're trying to proceed and why. With the prenuptial agreements, again, I consider myself, I'm 27-ish years in practice. I don't particularly, I've never wanted to do prenups and postnups, so I don't. They are not something that everybody does. If you are doing them, be sure that you fully understand this new statute. Do not use, for example, forms. My colleagues who do this are starting to see forms that are not right, that are not, if they're 8 years old and you're using a form, it's going to be wrong. So don't use forms. Don't rely on them totally, certainly. Obviously, if you've vetted and created your own form consistent with the statute, that's something different. But read and understand the law. If you do not understand the law of prenup, don't do it. That is my sort of Like the biggest pitfall you can have is a prenup that you drafted 17 years ago coming back and being found to have been invalid by something that you did. The malpractice tail on it is huge. It's not a place that you want to go if you don't feel very comfortable doing it within your capability and experience. So I think the prenup piece carries sort of the most peril for people, especially if it's not something you do very often. The maintenance statute, I could talk a whole day of things to think about, but key component things are update your forms. If I get a pleading from you and you talk about permanent maintenance, I'm going to be pretty confident that you are not up to date on what the law requires. If you are pleading something out or arguing it to the court and you're not using the language that the statute requires, or you're analyzing the wrong statute because you're using a decree that you wrote 2 years ago or a proposed findings that you did, 5 years ago, and you're analyzing, well, those are not the factors anymore. So be sure that when you are analyzing, writing a proposed order, mediating, that you open and read the statute. I, along with several other people, literally wrote this statute, and I still read it every single time I look at it to be sure that I'm not overlooking something. So just open the book and read the statute. They are now online. People had been indicating to me they hadn't been online. I know that they are up to date online now. If you have any other questions, I can't see if there's any in the chat just because I've got my screen up. So I've probably killed my mouse, so I can't get my screen to escape out and quit. But if anybody, let's see, there we go. Whew, look at my technology capability there. If you have questions, we certainly have a couple more minutes. If people want to ask them, I'm happy to answer them. Otherwise, I think they were going to make our emails available. And obviously you can track either one of us down on the internet where you can find our emails as well. But I'm happy to answer questions as people move forward. And also if people have feedback or criticism, they should definitely send that to Brian.
Yeah, and I'll take a moment before we wrap up here and just thank the scores of attorneys who worked on this inside the MSBA, inside the AAML, inside other organizations, legislative council in the House and Senate. There are a lot of people who spent a ton of time working on this, and I would say none more indispensable than Samantha. So if you want to say thank you to anyone in particular, I got paid to work on this. She volunteered probably 1,000 hours of time over the course of many, many years. And I just can't tell you how grateful I am for her and really glad we're able to get this done. So thanks everybody for joining us today. And as Samantha said, feel free to reach out if you have questions.
And if anyone wants the layout of the statute, there's a comment that it would have been helpful to people. I have had the opposite feedback in the couple times I've done this presentation, but if you want the red line statute, shoot me an email, and it literally lives on my desktop and in my actual hand at all times. So I'm happy to send it to you. Just shoot me an email and I'll do that. All right.
Thank you both. I don't see any questions here in the chat, so I'm going to go ahead and stop the recording.